agenda for today is just to roll through what happened to privacy in the last few years, and that's the second question is a little bit existential, but what's happening to privacy? Bob mentioned I want to leave you with a to-do list because I don't think any seminar is particularly useful without having a few points to think about for your own organisations. So firstly, looking at what's happened to privacy. Well, I think that particularly, in our personal time, our interactions with technology are creating an identity about who we are and what we browse, what we purchase, what we like or dislike, who we follow. And a wide range of businesses are collecting all of that information now because it's particularly useful. It helps us to predict what sort of marketing messages we should be delivering to quite a specific audience and to make those communications more meaningful. And as we collect more and more of that data, we have to remain conscious that a lot of the data we're collecting is personal information, which is information about an identifiable individual. And that's what our privacy laws protect. It protects the rights of these individuals in relation to their identifiable information. And it's fair to say we have an expectation of privacy in our lives generally, especially when it comes to the information that we choose to share with others. And that's exactly what our privacy law protects. Privacy is a human right, and it's ultimately overseen by our Human Rights Tribunal, but it's also overseen by our Privacy Commissioner. And when larger scale privacy breaches occur, it becomes quite newsworthy. And as we entrust our personal information more and more to organisations all over the world, those privacy breaches seem to be becoming almost a daily occurrence. Some of the high profile, sorry, just before I get to the profile examples, this slide just shows a few things about the sort of the time lapse of privacy laws around the world. When USA introduced its privacy laws, a personal camera looked a bit like this clumsy device. When Canada introduced its privacy laws back in the mid-1980s, a mobile phone was literally just a phone. It couldn't do much else. And back when New Zealand introduced the current Privacy Act in 1993, the only way to check your mail was the post box, and the only thing we knew about cookies was the things that we were baking in our ovens. But when you fast forward to today, all of these functions are becoming connected, and even something as simple as the phone that we're using can fulfill all of these different purposes. And so it's this interconnected dynamic that's enabling organisations to collect more and more information about who we are and what we do. And it's the intrusion of some of that technology into our daily lives that has led to some countries reacting with their privacy law. And one of the first big reactions was actually in Europe, where the GDPR was introduced. The GDPR is the General Data Protection Regulation, and it's EU's answer to the steady intrusion of technology on privacy rights. One of the main focuses of the GDPR is actually that it was in response to online monitoring of EU residents. And so one of the thoughts at the time that the GDPR was introduced was that organisations as far away from Europe as Silicon Valley were intruding on the privacy rights of EU citizens by monitoring their online habits and behaviours. And so the GDPR was brought together as an accumulation of various bits and pieces of European privacy law from all over Europe, including the UK Data Protection Act. And it's become what's widely renowned as a fairly high watermark for privacy protection, but it's also led to a second wave of regulatory change around the world as other countries have started to introduce tighter privacy laws to accommodate some of the concepts that were introduced into the GDPR. Sometimes that's because when we're trading with countries in Europe, we have to demonstrate that our own regulatory regime is comparable. Otherwise, we're no longer a safe harbour for information to be transferred to New Zealand. But there can be other reasons why we go through these regulatory changes ourselves. It helps that there have been some pretty high-profile examples of data breaches around the world over recent years. And when you look around in the reported cases of privacy breaches, some pretty big names pop up there. Facebook seems to be a fairly regular offender, but often by virtue of the fact it has just so many members. These are examples just in the last couple of years. Facebook had a data leak that involved phone numbers that were linked to a whole lot of Facebook user accounts, and that affected 419 million people. Marriott Hotels, similarly, they lost control of sensitive customer data, which included credit card details and passport details. Now, those sorts of things are a more sensitive category of personal information. And so our expectation of privacy around things like credit card details or financial transactions are higher than other types of personal information, such as our names or our email addresses. Unfortunately, that Marriott's data breach impacted 383 million customers. EasyJet had one, email addresses, travel details, and again, credit card details that affected 9 million passengers. And although we're using Zoom today, I remember not long before our first lockdown in New Zealand, Zoom suffered a data breach that impacted a number of its users, and there were 500,000 email addresses, passwords, and meeting URLs that were fell into the wrong hands and ended up being sold on the dark web, which is probably exactly where you don't want these things to be sold. More recently, some of the other big ones, some of you will remember Google+. There were a couple of data breaches that impacted around 52.5 million people, and that actually led to Google withdrawing that product. And that was probably the ultimate price to have to pay, just because of some security issues and some sloppy data privacy practices. Cambridge Analytica is probably topical, with Trump having attempted a second presidential campaign pretty recently, but back the first time around, there was a lot of press around Cambridge Analytica, where a genealogy app collected a lot of personal information. That information then flowed through to other organisations. Certainly the app users hadn't expected their information to end up in those hands, and it fed into Trump's presidential campaign. That affected 87 million people. Marriott's on there again with its customer loyalty database, 500 million affected. And surely one of the biggest data breaches of all time was actually the Indian government, which had failed to put really any security around the information that it retained on every Indian citizen. And so that affected 1.1 billion people. This slide just shows how there are, just in the last 2 years, sort of 2018 to 2020, a lot of those names are repeat offenders. They're on this diagram more than once. But there are some others too. Twitter's in there, 330 million users affected by that. And I was interested also to see MyFitnessPal. I don't know, those of you who might be using a fitness app like that. I remember a few years ago now that they were the subject of a data breach, and that impacted 150 million personal information records. And I remember that the press at the time, MyFitnessPal went on record and said that they would be following up with each of their users around that data breach. But the first I'd ever heard of it was when it hit the press, and I don't remember ever being contacted directly. But it's not just overseas that this is happening. Some examples that are a little bit closer to home: LPM Property Management. They lost control of personal information that included both active and expired passports, driver's license, evidence of age documents, photos, and that impacted 31,000 people. Wellington Kapiti and Wairarap's primary health organisation, that data breach was around their medical centre enrolment information, and it included names, ages, ethnicities, but also, again, more sensitive categories of personal information like health information. Naturally, we have an expectation of privacy around health records, and so they attract an extra layer of protection, if you like, under our Health Information Privacy Code. Now, that affected up to 1 million New Zealanders, not because that geographic area had such a high population, but because the information records spanned from 2002 to 2019. And there was an example with one of our KiwiSaver providers, Generate, 26,000 people affected by that, and that was a breach in relation to the online application database. So I guess what we're learning is that bigger isn't always better when it comes to data practices and privacy compliance. So turning then to what's happening to privacy, I mentioned a little bit already around the GDPR in Europe and the impact that's had globally, that a lot of countries now are looking at how they can raise the bar for privacy compliance and privacy regulations so that they are nearer to that high watermark in Europe. Closer to home though, what this slide shows is that the new act that comes into force here on 1 December has been a little while in the making, and our current Privacy Act dates back to 1993. It's a bit out of date, but it's interesting to note that the Privacy Commissioner undertook the first review of that 1993 Act only 5 years after it was enacted, and already commented that it was starting to fall out of step with the rapid pace of technology change. Move on another 10 years or so, and the New Zealand Law Commission completed a further review, and from there, eventually, the Privacy Bill was introduced to Parliament in 2018. Now, it took a little while to work through and become enacted, but and we'll look at some of the reasons why that was. But from 1 December, literally next month, we've got brand new privacy law, and it's a complete rewrite of the 93 Act. Well, no, that's not actually true. It's not a rewrite of the Act. It preserves actually a huge core of the current Privacy Act. It makes a few changes to some of those existing concepts, and we'll explore one of those. But it does introduce a couple of new features, and I think those features are probably two of the aspects of the new Act that will have the most impact on the largest number of organisations in New Zealand. So what's new? Those of you who are familiar with the Privacy Act might know that at the core of our existing Act, there are 12 information privacy principles. Well, that doesn't change. Those are still the core of the Act. And there's now one more. There's a 13th privacy principle, 13, a lucky number for some. The Privacy Commissioner has managed to increase the penalties under the new Act, although not significantly. The penalties are moving up from, I think, currently $4,000 as a maximum penalty an organisation might face, up to now $10,000. The Privacy Commissioner has been a little bit upset about that. When you look to some of our nearest neighbours in Australia, I think the highest penalty is around 250,000 Australian dollars. Looking further afield, the maximum penalty under the GDPR in Europe is 20 million euros, or 4% of your global turnover. And if you're a multinational business, 4% of your global turnover could well be more than 20 million euros. And so whichever is the higher amount would be the maximum penalty that could be imposed on your organisation. And that alone is quite significant incentive to comply with privacy law. Now, $10,000 in New Zealand, not such an incentive for most organisations, but some of the new features of the 2020 Act will become more of a motivation, I think. And so we're going to look at Part 6 of the Act, which is new. There's a brand new mandatory breach reporting regime, which follows some of the themes that were introduced under the GDPR and which has already been enacted in Australia. And we'll also look at a new power that the Privacy Commissioner has, which is to issue compliance notices. And that is essentially a notice to instruct your organisation to either do something or to stop doing something in order to comply with privacy law. So let's look at each of those ones in turn. Firstly, mandatory breach reporting. When the 2020 Act was introduced in its bill form back in 2018, the concept of mandatory breach reporting was included in the bill. And essentially, the concept is that if a privacy breach is sufficiently grave, you would have to notify the affected individuals and also notify our Privacy Commissioner. Now, this received a lot of submissions as the bill was tracking through Parliament. And part of the issue was that there were some concerns that if there was a need to notify privacy breaches, but there was no guidance as to what sort of breaches would be grave enough that they should be notified, then there might be over-reporting. And the Privacy Commissioner shared that concern that he would be literally swamped with paperwork, people taking an overly cautious approach perhaps. And so as the bill worked its way through Parliament over the next 18 months to 2 years, a further component was introduced, and that was that of serious harm. So that if a privacy breach was likely to cause serious harm to the affected individuals, then it would become notifiable. So essentially a notifiable breach is any breach where there's been an unauthorized or an accidental access to or disclosure of or alteration or destruction of personal information which has caused or is likely to cause serious harm. And in those cases, your organisation needs to notify the Privacy Commissioner and also notify those affected individuals. Now that's where I think the new Act will start to get a lot more traction, a lot more attention among New Zealand businesses, because the idea of having to notify a privacy breach to the Privacy Commissioner is quite concerning. And you might be more concerned to learn that once you've notified that breach, the Privacy Commissioner is likely to put up a brief summary of the event on the Office of the Privacy Commissioner's website. So you have a permanent record, if you like, of a privacy breach that might have been caused by human error or perhaps a third party intrusion in, beyond your security in your organisation. Nevertheless, your business name ends up being sort of permanently recorded on the public record in that way. And so there's a strong reputational risk, and I think that's what will drive organisations to seek to comply with the new law. And when you're notifying the Privacy Commissioner about a privacy breach, you really need to be able to firstly make an assessment of the likelihood of serious harm. And that could require a few stakeholders in your business to join forces and have their say and try and make an assessment about whether the breach has been serious enough or impactful enough on individuals to warrant reporting it to those individuals and to the Privacy Commissioner. If your assessment is that you need to report the breach, then you need to be ready to describe the breach, including the number of people that are affected, the identity of the person or the organisation that's suspected of gaining unauthorised access to the personal information, and also to outline the steps that your organisation's already taken or that you intend to take to minimise the harm, and identify any other agency that you might need to advise of the privacy breach And that might be, for instance, your lawyers, it might be your insurers, or if you outsource part of your IT function, you might need to contact them to take steps, or you may even need to contact the police if there's going to be an investigation into the breach. And if your assessment is that you don't need to report the breach, you would still need to be prepared to provide the reasons why. So the Privacy Commissioner is going to be concerned to know that you've gone through this assessment, even if ultimately you've decided that the breach is not likely to cause a serious harm. When you're notifying the affected individuals, it's a very, very similar list. You'll need to notify each individual as soon as is practicable. And if you can't notify each person, then you'll need to issue a public notice, which again comes back to that reputational risk. You'll need to describe the breach, including the number of people that have been affected, the identity of any person or organisation that you suspect has gained unauthorised access to that information. But don't name that organisation or the person who's gained unauthorised access unless that's to prevent a serious threat. And you'll need to outline the steps already taken or that you're intending to take to minimise the harm. And again, recommend any steps the individual can take to mitigate or avoid potential loss. And one of those steps might be something as simple as changing their passwords. And you'll need to note to those individuals that you've contacted the Privacy Commissioner. And it's worth reminding you also that really your organisation should not disclose any information about other individuals that have been affected, because that's actually a really good way where there might be a subsequent privacy breach if you were to email all of the people initially affected, include all their emails in the to field or the CC field or something like that. That would actually be a further breach of privacy of those individuals. So important to communicate one-on-one with those individuals and not mention the identity of the other individuals that might have been affected. And of course, if you fail to report a notifiable breach, your organisation could face that fine of up to $10,000. But how do you assess whether there's been a serious harm? And this is another factor that slowed down the passage of the Privacy Bill through to its final form that comes into force on 1 December. The new Act doesn't really tell you how to assess that, but it does give you some guidelines or some factors that you have to consider. And so those factors are all on this slide, and I've highlighted A and E because I think they're worth a little bit more exploration. So if you're trying to assess serious harm, your organisation would need to think about at least whether any action's been taken by your business to reduce the risk of harm after the privacy breach, whether the personal information is sensitive in nature, the nature of the harm that may be caused to the affected individuals, the personal body that's gained unauthorised access to the personal information, whether the personal information is protected by some security measure, and a sort of a catch-all at the end, any other relevant matters. So there's a lot of scope really for your businesses to make up your own minds about whether a serious harm could result from the privacy breach. But these factors start to reveal a couple of things. Firstly, that it's not whether you personally would feel you would suffer a serious harm from the particular breach. You have to really put yourselves in the shoes of the individuals and whether they would be of a mindset that they would suffer a serious harm. And so what could cause a serious harm to certain individuals may not cause a serious harm to others. And for instance, if the privacy breach revealed some address information, now our personal addresses may not necessarily be so sensitive in nature, and we may not feel that we suffer a serious harm from that. But if if you were an individual who was escaping a violent relationship, and your current address was quite confidential and quite well protected, then for you personally, a data breach that involved or revealed your address, that could be particularly harmful. So the first factor to think about is that you really need to put yourself in the shoes of the individuals concerned to the extent that you can, and make that assessment from their perspective. The second point that this slide raises is that those highlighted points A and E, they start to suggest that while technology has been to some extent viewed as part of the problem, or why there's been a steady erosion of privacy rights, technology might also be part of the solution. What actions has your business taken to reduce the harm following a privacy breach? Well, technology or IT security could be one of those actions. And likewise with point E, whether the personal information is protected by a security measure. So a good example would be where somebody gains unauthorized access to a data file which contains personal information, and technically that might be a privacy breach. But if the information is encrypted, then whoever's managed to get hold of that file in an unauthorized way still can't access the personal information. And so in that scenario, it seems that a serious harm is not likely to result. So technology could come to the rescue. We'll have a quick look at compliance notices. And the reason this is noteworthy is that it's the first time the Privacy Commissioner has had the power to direct a business to do something or to stop doing something in order to comply with privacy law. And it's not necessarily a breach of those 13 privacy principles that might lead to a compliance notice. The Privacy Commissioner might issue a compliance notice where there's been any breach of the Privacy Act, or there's been any interference with the privacy of an individual under some other act. And conceivably that could be the Human Rights Act, or perhaps something that overlaps with the Privacy Act generally is the Unsolicited Electronic Messages Act, which is our law that governs when we're permitted to send electronic marketing messages. So those are two examples where the Privacy Commissioner may decide that actually the harm is better dealt with under another act, but nevertheless, the Privacy Commissioner might issue a compliance notice. And the Privacy Commissioner has also gone on record stating that he's likely to collaborate with other regulatory authorities and take a much more collaborative approach to pursuing businesses that have demonstrated poor trade practices or poor privacy practices. So we can expect a collaboration between regulatory authorities, and I think also in the new year we can expect that the Privacy Commissioner will have issued a few compliance notices, will have exercised this new power. And fortunately, though, there's a few things that the Commissioner has to consider before he issues a compliance notice. So before that notice is issued, the Privacy Commissioner needs to think about whether there's another means under the Privacy Act or another act that could deal with the breach. He needs to consider the seriousness of the breach, not the serious harm, but the seriousness of the breach. The likelihood of a repeat of the breach, the number of people who have been affected by the breach, whether the business that suffered that privacy breach has been cooperative in all dealings with the Privacy Commissioner. That's a juicy one. And the likely costs of the business complying with the compliance notice. So what we're seeing is that the Privacy Commissioner is likely to take a more measured approach and is not going to direct a business to do something where, for instance, the cost of complying would be out of proportion with the potential harm or risk of the privacy breach happening again. And as I mentioned earlier, the Commissioner does not need to assess whether any person has suffered harm. They're really looking at different materiality questions about the seriousness of the breach, the likelihood of that the breach might be repeated, and so on. So quite apart from the impact that it has on individuals, I would imagine that the Privacy Commissioner is going to be keenly interested in regular offenders, but also first-time offenders where there are a lot of people or a lot of personal information impacted. So the other key change, and probably the last one that we really need to discuss today, is the new information privacy principle, which deals with cross-border data transfers. And increasingly, this is just a normal part of everyday life, because a lot of businesses will outsource some of their business processes to an overseas technology provider. It might even be something as simple as your payroll function ends up being supported in the cloud or run by a vendor whose infrastructure is sitting in Singapore or the US or somewhere else. The 1993 Act only really scratched the surface around how the transfer of personal information overseas should be dealt with. And really all it said was that your organisation could not escape their privacy obligations simply by transferring the information out of New Zealand. You would continue to need to comply with New Zealand privacy law even after you've transferred the information overseas. And what Information Privacy Principle 12 does is it expands on some of the ways that you can satisfy yourself that your organisation is authorised to send the information overseas in the first place. The easiest way is that you can make an assessment of the privacy laws in that overseas country and determine that they are at least as robust as New Zealand privacy law. That would be one way that you'd be permitted to transfer information to an overseas recipient. Or you could impose quite specific obligations on the overseas recipient that are consistent with our New Zealand privacy laws. And that way, through a contract, you're passing on an obligation to ensure that the overseas recipient doesn't drop the ball and become the weakest link in your compliance chain. But even if you can't do either of those things, you can still transfer information overseas with the authorization of the individual. And that needs to be informed authorization. And so really you need to explain to them what the risks are in transferring the information to a jurisdiction that may not have adequate privacy laws, or where you may not be able to put contractual obligations in place to bolster the recipient's privacy practices. Fortunately, the 2020 Act also brings through an exclusion which was incorporated in our existing 1993 privacy law. And so both the 93 Act and the 2020 Act both recognise that you won't need to go through those steps or assessments around the overseas country's privacy law and so on, where all you're doing is transferring data for the purposes of data processing or hosting, and the overseas recipient is acting just as an agent for your business. So this is what I would refer to as closed loop processing. Information may well leave your business and circle through a cloud service, for instance, but as long as that process is only fulfilling a function for your business, then you're likely to fall into this exception, and that transfer of information is no longer a disclosure for the purposes of the Privacy Act, and so you won't need to go through the extra steps contemplated in Information Privacy Principle 12. One of the factors to look out for, though, is whether that overseas service provider is also using or processing the personal information for its own purposes. And if that's the case, then you need to look again at complying with Information Privacy Principle 12 rather than leaning on this exclusion for data processing or hosting. Okay, and the final point really was not so much of a change, but a clarification around how our New Zealand privacy law applies to activities or businesses that are located outside New Zealand. And although the 1993 Act dealt with this to some extent, the 2020 Act tries to clarify that a New Zealand business might still be subject to our privacy law, even though its activities are overseas. And similarly, an overseas business might become subject to our New Zealand privacy law just by virtue of its particular activities in New Zealand. And the Act does clarify what carrying on business in New Zealand means, and it can mean it can mean that an overseas business, for instance, is delivering a marketing campaign that's quite specifically focused on New Zealanders or in a New Zealand audience, advertising to people in New Zealand and so on. And some of the other examples might be where an overseas business is pricing its products or services in New Zealand dollars. You know, that alone might be enough to draw that organisation into needing to comply with New Zealand privacy law. That brings us to the end of the substantive content and the key new features. But it begs the question, what does your organisation need to do and what do you need to think about in order to comply with this new law? And really at the heart of it, we're still in a privacy regime where consent goes a long way. So the consent of the individuals whose information you're collecting or processing or sharing, that consent can authorise you to do a lot of things. But that's been part of the problem over recent years, is that because we're accustomed to giving up our personal information, particularly when we're interacting with technology, it's almost got to the point where organizations feel that personal information is just data that can be transacted freely. What these tighter privacy laws are reminding us of is that actually privacy is a fundamental human right. So when we're entrusted with somebody's personal information, their expectation is that we're not going to transact that data unless we've been quite upfront about how those transactions would take place, who we would share the information with, and so on. And so I think that the 2020 Act really is challenging us to look again at what personal information is and how we deal with it, and to be more responsible and more accountable for our privacy practices. And certainly with the mandatory breach reporting, businesses are more accountable to the Privacy Commissioner and also to the affected individuals. Another good step to take would be to have a look at your own privacy policies and procedures, because at the moment we're quite busy updating privacy policies for a number of our clients, at least to contemplate the new Privacy Principle 12 and possibly drill down a little bit around how information might be transferred overseas. Another key change I think that a lot of businesses will embrace is that the role of a privacy officer within your business, which actually has been a mandatory role ever since 1993, but admittedly not all businesses would have a privacy officer. The privacy officer really needs to be empowered to be able to make decisions and take steps quite quickly, especially around these assessments of serious harm and whether a breach should be reported or not to the Privacy Commissioner. And so that might start to change some of the internal reporting lines within your business, because the Privacy Commissioner may need to have quite quick, reliable access to decision makers such as the CEO. And those two people might need to sit down assess the privacy breach, decide if there's a serious harm, and then move into the action phase. What are the next steps? So we're talking about teams and people within your organization needing to be quite well resourced so that they can act quickly. And for the reasons that I made earlier on, linking some of those concepts around security, information security, potentially making the difference between a notifiable privacy breach and a breach that doesn't need to be notified, have a think about stepping up security around your personal information that you're managing, looking at Privacy Principle 5, which basically tells us that we need to take security steps or implement security measures that are reasonable in the circumstances to protect against unauthorized access to personal information. Data moving overseas, it's not necessarily just the privacy policy that needs a refresh on this. If you are outsourcing a business function to an overseas service provider, there'll be a contract in place. It might be timely to have a look at that contract and see what it says about that overseas supplier's data practices. Sometimes we find that they subscribe to international privacy standards. There's an ISO standard, for instance, that relates to privacy. Sometimes, though, we find that those global best practice standards are mentioned, but the provider is not actually audited or certified to that level. They simply try to attain it, and that's quite different to an organization who's actually been certified and has achieved all of those requirements and been certified under, for instance, ISO. So the contract review stages at the moment, focusing on suppliers. Are their privacy obligations consistent with yours? Are they subscribing to a data privacy standard? There are model clauses. The slide says they're on the way. Actually, the Privacy Commissioner has now published some model clauses, so kind of template clauses that you could look at including in your contracts with overseas service providers, passing on those obligations so that you know that they are going to be handling personal information for you in a way that's consistent with our New Zealand privacy law.